Welcome back to part 2, where the initiative really comes into play, and as the main motivation for the initiative is in the case where the parent chooses alternative education options to the government schools. The government's already stuck its bloody nose into the affairs of alternative schools. It just can't leave anyone alone. It thinks it has superior knowledge and compassion for children, and thus that it must control what the child learns. This will be a particularly pervasive problem in the future as parents seek to find education that doesn't render their children functional illiterate, as the government schools do. And it's going to really rear its ugly head when the education tax relief becomes the law of the land, and parents will then have funds to seek alternative schools, and they'll do so in droves. So this initiative is complementary to the Education Tax Relief Act in that it will prohibit the government from interfering with the parents' choices of educational curriculum. This initiative will get the government off the backs of parents. You know, if the government has such superior knowledge and compassion for our children, why does it use its government schools to turn out functional literates, or destroy their morals, or shoot them up with dangerous and even killer drugs, and promote unhealthy death styles? You know, it's a blatant lie that the government knows best and is a superior caregiver. Government only destroys. It never gives life. It kills life. You might be tempted to show a blasé attitude toward this seemingly unimportant and innocuous initiative, but it is actually extremely important and urgently needed. There are several real-world cases that illustrate the need for this initiative. One case, in a December 4th, 2009 article published by WorldNet Daily titled, "Judge, Parents Bigots for Opposing Gay Lessons." They reported that, and I quote from the article, "A judge has attacked parents, suggesting they are bigots for seeking to opt out their elementary-age children from a mandatory, controversial, pro-homosexual curriculum, according to a nonprofit law firm." The parents were represented in the California's Alameda Superior Court by the Pacific Justice Institute. So last December, on December 1st, Judge Frank Reich denied a motion to allow them to have their children excused from the lessons. According to the group, Reich blasted the parents for seeking enforcement of a provision of the California Education Code that gives parents to opt out their kids from health education. That's Education Code Section 51240 allows the parent to have a student excused from instruction if any part of the school's instruction in health conflicts with the religious training and beliefs of a parent or guardian or pupil. However, Pacific Justice Institute said Royce repeatedly insinuated the parents are bigots and insisted there can be no homosexual indoctrination because, he purportedly argued, people are born that way. Now, there's no evidence of that. All the studies that's purported to show that have been debunked. It's just not the case. They're not born that way. It's a choice. So in his opinion, Royce said the opt-out provision in Section 51240 is not reasonably construed to include instruction in family life education. Well, it was intended to be more limited in scope. The judge equated a view contrary to his own with creationism and called him false, according to the Pacific Justice Institute. So the Parental Protection Act of 2010 will stop biased judges like Judge Royce in their tracks by giving parents the clear, unambiguous authority to establish what curriculum they will allow their kids to be exposed to. In a second case, presented in a November 24th, 2009 WorldNet Daily article titled "Hearing for Homeschooler Forced into Government System." What the article said was the New Hampshire Supreme Court has agreed to hear the case of a 10-year-old homeschool girl who's been ordered into a government-run school because she was too vigorous in defense of her Christian faith. WorldNet Daily earlier had reported the girl that identified in court documents as Amanda was described as well-liked, social, interactive with her peers, academically promising, and intellectually at or superior to grade level. That didn't matter. The New Hampshire court official determined she would be better off in public school rather than continuing her homeschool education. Obviously the parents thought different, but no, the judge, he's got his own, he knows, you know. So the August decision from Marshal Master Michael Garner reasoned that Amanda's vigorous defense of her religious beliefs to her counselor strongly suggests that she has not had the opportunity to seriously consider any other point of view. What? Is this guy omniscient or something? how does he know she hasn't considered many points of view, decided on one, and is confident enough to express that? I mean, how does he know? He doesn't have any data that he can say what he said, because he said that her beliefs, the way she defended her beliefs, strongly suggests she has not had the opportunity. So he has no evidence that she has not had the opportunity. This arrogance of the judicial system, or the judges in our judicial system, is unbelievable. So anyway, that recommendation was approved by Judge Lucinda Sadler, but it's being challenged by attorneys from the Alliance Defense Fund. They said it was going a step too far for any court. So they filed motions with the court on August 24th, seeking reconsideration of the order and a stay of the decision, which will send the 10-year-old Amanda to government-run schools in Meredith, New Hampshire. On September 17th, the lower court judge refused to reconsider or stay the order. So the judicial system thinks it has more knowledge and is better qualified to determine where the child's re-educated than the parents. So they're saying, no, you got to put her in the government school system. Judges are saying this against the parents' wishes. The denial of motion signed by Judge Sadler of the Family Division of the Judicial Court for Belknap County, Laconia, states, Amanda is at an age where it can be expected that she would benefit from the social interaction and problem solving she will find in public school, and granting a stay would result in a lost opportunity for her. Well, now that New Hampshire Supreme Court is going to hear that, the ADF Senior Counsel Mike Johnson said that the lower court was setting a dangerous standard. He said, we're concerned anytime a court oversteps its bounds to tread on the right of a parent to make sound educational choices, or to discredit the inherent value of the homeschooling option. The lower court effectively determined there would be a lost opportunity if a child's Christian views are not sifted and challenged in a public school setting. We regard this as a dangerous precedent, and I'd have to agree with that. So here's the court saying if a girl's educated in a homeschool, there'll be a lost opportunity if her Christian views aren't challenged in a public school setting. Well, what about the lost opportunity when students in a public school setting's views are not challenged by Christian views? Why isn't that a lost opportunity? It's a one-way deal. Now, it wasn't always the case that government believed its rights were superior to parents' rights. So click on part 3 for more about abuse of parents' rights and about the California Protection Act, and I'll tell you about why it wasn't always the case. I'll see you there.